Welcome, everybody. Welcome to today's episode of the Law of Self-Defense. Let's see. Let's make sure I have my settings correct. And it looks like I do. All right. Awesome. Obviously, I'm in a hotel room. I'm in Boerne, Texas. I don't have my usual setup here. This is my little, I call it my travel studio. I hope everybody can hear me okay. If I can get an audio check, that would be awesome. And let me make sure everything is working the way it needs to be working. All right. That was me talking to myself. And it looks like everything is. All right. Awesome. So we're here today to talk about citizen's arrest. Just a little bit. I have to be quick, folks. It has to be a relatively short show today because I'm going to get kicked out of this hotel room at the top of the hour. So I don't have all that much time. But there was an event that took place in Georgia. Apparently, a crazy woman, I think it was a woman, apparently attempted to burn down the birth home of Martin Luther King Jr. in Atlanta. She was sloshing gasoline onto the structure. Arson of a structure, obviously a felony crime. Fortunately, two tourists from Utah who were visiting the site saw what was happening and intervened to stop her. And then they were assisted by two off-duty NYPD cops who made a citizen's arrest and detained the arson suspect for Atlanta police, which, of course, is exactly what society should want all these people to be doing, right? Preventing someone from committing arson of any sort, but particularly of a historic site. We want them to intervene. The question arises, however, whether what any of these people did was actually lawful under Georgia law. And if it was unlawful, if the citizen's arrest and detentions were unlawful and things had escalated to a forceful confrontation, one involving violence, and these interveners, these citizens, had to kill the suspect, would they be looking at a potential life sentence in prison because their citizen's arrest was not lawful, and therefore arguably, nothing that followed was lawful? There is that risk under Georgia law. We're going to take a look at the law and the facts of this case in more detail. And with that out of the way, let's go ahead and jump into the formal start of today's show. And before we jump in, I do, of course, have to mention our sponsor of today's show, which is none other than Law of Self-Defense itself, in the form of our book, Law of Self-Defense Principles, the handbook to making yourself hard to convict if you're ever compelled to use force in defense of yourself, your family, your property, maybe someone else's property, like Martin Luther King Jr.'s birth site. You can get this book for free at lawofselfdefense.com/free book. I do encourage you to check the book out on Amazon. You'll see it's 5-star rated, well over 1,500, I think, reviews. But don't buy it on Amazon. Amazon will charge you for the book and the shipping and handling. We only ask that you cover the cost of shipping the book to you. The book itself is free, and you can get your copy for yourself or loved ones. Gift giving season is coming up, folks. There's an option to get more than one copy if you want. Again, at lawofselfdefense.com/free book. All right. So with that out of the way, let's take a look at what we have here. I've got this tweet to share. That's how I became aware of this. And it reads, a woman arrested after trying to burn down Martin Luther King Jr.'s birth home in Atlanta, stopped by off-duty NYPD officers. Actually, I think it was the Utah tourist that stopped her. A woman attempted to burn down Martin Luther King Jr.'s birth home, arriving with a gas canister and dousing the historic property in fuel Thursday. Two tourists from Utah viewing the home were able to intervene to stop the suspect, police said. The suspect, arsonist, was then quickly detained by two off-duty NYPD officers who had been visiting the historical landmark and held her until Atlanta police arrived. The suspect, 26, has been charged with criminal attempt arson and criminal attempt interference with government property. Police have not released her name. I don't know why. Now, probably this is just an insane woman an insane person. I do have video that was taken probably by the Utah tourists. It may have been incidental. They may just have, been filming the home as part of their tourist activities when this lunatic showed up with a gas can. So here is that video. There's not much to see, but there's all there is. So I'll share it with you. Splashing gas.
What are you doing? What are you doing? No, that's gasoline.
And there's the suspect being restrained. I believe this must be the two NYPD cops at this point. And they just hold her there. There's nothing really to see. So let's take a look at the law of citizen's arrest. Now, normally detaining someone like this would be unlawful, right? You're not allowed to just go around detaining people. So you would need a legal justification for your use of force, for your detention of another person to be lawful. Let's see if I can fix this up a little bit. It'll make our post-production guys happier. And fortunately, under Georgia law, conduct that would normally be unlawful, like an unlawful detention, a false imprisonment, which can be a felony, folks, can not be a crime if you can justify it according to one of the conditions in the law for justification. And here we have Georgia's general justification statute. And it reads, the fact that a person's conduct is justified is a defense to prosecution for any crime based on that conduct. So you commit an act that would normally be criminal, but if it's legally justified, it's simply not a crime any longer. The defense of justification can be claimed, and the first section here is just a bunch of self-defense, use of force in defense of self, others, property statutes. But the one we're really interested in is D, when the person's conduct is reasonable and is performed in the course of making a lawful arrest. So your detention of that person, which would otherwise be criminal false imprisonment, becomes legally justified and not a crime when that detention is in the course of making a lawful arrest, which begs the question, what is a lawful arrest? Well, fortunately, Georgia also has a citizen's arrest statute, or at least it used to. It used to. This is the old citizen's arrest statute, and I'm just using the Law of Self-Defense website for this. This is access to statutes that we keep updated for our members with our own annotations. So it's another benefit of being a Law of Self-Defense member, folks, is you get access to this kind of stuff. So you might consider becoming a Law of Self-Defense member for 99 cents. 99 cents, folks. That's all it takes to be a Law of Self-Defense member. For a 2-week trial, membership gets you unlimited access to all our member content. And if you stay a member after the fact, it's still only 30 cents a day, about less than $10 a month to be a Law of Self-Defense member. And we only answer during these live streams questions and comments that come in on the member dashboard, the live stream for our members in the chat section. We don't answer questions, address comments in YouTube, Rumble, Twitter. The member dashboard is the only place. So if you'd like to be able to engage with me directly during these live streams, you have to be a Law of Self-Defense member. You can sign up right now, get emailed instantly instructions for accessing the member live stream at lawofselfdefense.com/trial. Just 99 cents, folks. It's pretty inexpensive. Okay, so let's take a look at Georgia's old citizen's arrest statute. It read, and this is section 17460, grounds for arrest. A private person, it's only 2 sentences, remarkably. A private person may arrest an offender if the offense is committed in his presence, the arrester's presence, or within his immediate knowledge. And Georgia courts have said those are the same things. That's the first sentence. So if a crime's committed in your presence, you're observing it, you can arrest that offender under Georgia law. Whether it's a misdemeanor, whether it's a felony, it just needs to be an offense, a criminal offense committed in your presence. That's the first sentence. The second sentence is more specific. It refers explicitly to 1, felonies only, and 2, where the person committing the crime is attempting to escape. So it's a subset of the general privilege to make an arrest. If the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion. So what's the difference between the first sentence and the second sentence? The first sentence says, hey, even if they're just committing a misdemeanor, if you observe it happening, you can make a citizen's arrest of that person. The second sentence says, if what's involved is a felony and they're in flight, so not just a misdemeanor, it has to be a more serious crime, but if they're committing a felony level crime and they're in flight, you don't need to have observed the felony. All that's required is that you have reasonable suspicion that there was a felony, which means you could rely on things like circumstantial evidence, right? You hear glass breaking, you see someone running, you do 1 + 1 = 2. You didn't actually see them break the window, right? That's what reasonable and probable grounds of suspicion, not personal observation. Now, this was the citizen's arrest statute that was in effect during the Ahmaud Arbery killing down in Georgia. And as you might see, it's a pretty broad statute. And arguably, there is some ambiguity. I don't see much ambiguity. I read this as pretty broad. Other people disagreed with my interpretation. I'm not going to re-argue all that. You can come to your own assessment, I guess. One thing that really bothered me about the Ahmaud Arbery trial was, to the extent there's ambiguity, it's the job of the trial judge to clarify that ambiguity and tell the jury what the statute means. It's not for the jury to decide what the law means. The jury is the finder of fact. They decide what facts they believe were proven or disproven or not proven in the course of the trial, and then they're instructed by the judge on the law on how to apply the law to the facts as the jury has found the facts to be. And the judge never did that in this case. There was substantial argument between the state and the defense about what exactly this citizen's arrest statute means, and the judge just said, "Meh, I'm going to let the jury decide." He just decided not to do his job. Now, I think a reasonable person could argue that this citizen's arrest statute is too broad, at least in the modern era. I think that argument can be made with a straight face. And part of the issue here is that this statute is very, very old. It was first passed into law in 1863. It hasn't seen much adjustment since then. 1863, folks. That's a long time ago. It uses phrases, reasonable and probable grounds of suspicion, that sound like legal terms of art that are in common use in criminal law today in the context of arrest. But our modern understanding of those words is a function of a series of U.S. Supreme Court decisions that took place in the 1950s, so 90 years after this statute became law. So what those words mean here is not necessarily what they would mean if this statute was passed in 2023. In any case, the argument over the precise meaning of this citizen's arrest statute and the possibility that it could have justified their pursuit of Ahmaud Arbery by the McMichaels, father and son, and Roddy Bryan, that it could have justified their pursuit and their killing of Ahmaud Arbery, which is certainly an argument I made, outraged so many people because, of course, the Arbery trial was highly politically energized. Anyone who entertained any possible notion that perhaps the killing was not unlawful is obviously a racist. So the fact that this citizen's arrest statute might be used to let the killers get away with the crime so outraged the public that they demanded that this citizen's arrest statute be repealed. Now, again, I think reasonable people could decide, well, in the modern era, 1863, folks, there were not many professional police departments. Mostly the citizenry was making arrests of criminals. There were no cops to call. Well, we don't live in 1863 anymore. So maybe this needs to be tightened up for the modern era in which, in theory, there's police departments everywhere. And I could see the Georgia legislature taking that path in a reasonable way. What they did instead is they basically entirely eliminated citizen's arrest in Georgia. They kept what's called a shopkeeper's privilege. So a shopkeeper's privilege is a particular form of citizen's arrest where a shopkeeper has a reasonable suspicion that someone is shoplifting in their store, and they can detain that shoplifter while they call the police until the police arrive, so the police can question that person. but it only applies in the shopkeeper context, right? Not you walking down the street and you happen to observe some criminal activity taking place. What Georgia did was they kept the shopkeeper's privilege, but they eliminated essentially every other form of citizen's arrest. That happened on May 10th, 2021, a year or two after the Ahmaud Arbery killing. And here's the new statute. The new citizen's arrest statute in Georgia limited detention by certain private individuals for certain offenses. I mean, the title alone tells you they're tightening this up. It's not any offense. It's not any private individual, which is what the old citizen's arrest statute says. So this one has some definitions in the first paragraph. I'm going to skip over those. I'll just jump to paragraph B, where it says a private person may detain an individual if such private person is an owner of a retail establishment, an owner of a food service establishment, an owner of any business entity operating on their own property, a weight inspector for the state, a licensee or registrant of some other official capacity. That's it, folks. Those 5 specific categories of individuals have a limited privilege to make a citizen's arrest. If you don't fit in one of those 5 categories, you have 0 privilege for citizen's arrest. And if any of these individuals are outside the limited context, outside of their business, for example, or outside what they're arresting for, they have no legal privilege to make a citizen's arrest. So when we look at the story here of these people from Utah observing an arson attempt, arson's a terrible crime, right? I mean, set aside the historical context, which just makes it worse. But if it's anybody's home and they're splashing gasoline on it, they're going to burn it down. That's horrible. That's a felony. Should people be allowed to make a citizen's arrest if they observe directly that kind of conduct happening right in front of them? Yes, they should. Does Georgia law provide for any legal privilege for those people from Utah to make a citizen's arrest? No, it does not. They're not any of these 5 categories of people. They're not the owner of a retail establishment. They're not the owner of a food service establishment. They're not the owner of a business entity operating who believes some individual needs to be detained for committing a theft. They're not a weight inspector. They're not a licensee under Chapter 38, Title 43, whatever that is. They're just tourists. They literally have 0 privilege to make a citizen's arrest of this crazy arsonist. So they could potentially be looking at a false imprisonment charge, which is a felony. And what if things escalate? What if that person they're unlawfully arresting resists the arrest and things get violent? Well, if it's unlawful arrest, that person is allowed to resist their attempt to arrest him. That person's resistance is lawful force against their unlawful arrest. That person is the innocent party, and they, these well-intentioned tourists, are the unlawful physical aggressors against which that arsonist, crazy, can defend their arrest attempt. This just goes to show that the Georgia legislature did not really think out this citizen's arrest statute. It was done in the heat of passion following the highly politicized Ahmaud Arbery case. They just eliminated citizen's arrest for all practical purposes. Now, what about the cops here? Well, they're cops, right? Cops can make an arrest. But of course, they're NYPD cops. They're not Georgia cops. Now, I didn't have time to dig into all the details of what out-of-state jurisdictions Georgia might allow to make an arrest in their state. That could be broad. Maybe these NYPD guys were making a lawful arrest. Normally, if a cop's out of his jurisdiction, he's just making a citizen's arrest, like any other person, in theory, could do, except in Georgia. And I expect that might be the case here. And one of the reasons I expect that is because Georgia does have a very interesting law addressing the privilege of out-of-state cops making arrests in Georgia. This is it. It's 35-115, fresh pursuit by law enforcement officers. Fresh pursuit means pursuit by a law enforcement officer of a person who is in immediate and continuous flight from the commission of a criminal offense. Makes sense? Law enforcement officer means a person employed or appointed by a state or political subdivision who is granted by state law the authority to enforce criminal laws. of their respective state who possesses the power to effect arrests. Well, that would be a cop anywhere, basically. But then we get to this weird paragraph, B. So does that mean a cop from anywhere can make an arrest in Georgia and have it be lawful? Well, no, because this statute narrows down the officers who qualify for this arrest privilege, depending on whether they live in a state close to Georgia. A law enforcement officer from Alabama, Florida, North Carolina, South Carolina, or Tennessee who enters this state in fresh pursuit of a person shall have the same authority to arrest and hold in custody such person within this state as that of a law enforcement officer of this state. Well, first of all, in this case, there was no fresh pursuit, right? These NYPD guys were not engaged in fresh pursuit of a criminal from the scene of a crime, the commission of a crime. But even if they had been, these cops are from New York. They're not from Alabama, Florida, North Carolina, South Carolina, or Tennessee. And why would Georgia have this statute that delimits the arrest authority to these specific state jurisdictions if they intended to allow an arrest authority for cops from any jurisdiction? That doesn't make any sense to me. Now, my area of expertise is use of force law, when you can defend yourself, your family, your property. It's not police jurisdiction law. To have an authoritative opinion on this, I'd have to do a lot more research on it. Maybe those of you in the law self-defense membership who are cops would have something to say about this. But it could be even those NYPD cops were not engaged in a lawful arrest of this arson suspect and were acting in false imprisonment, just as were the Utah tourists. And if things had escalated to deadly force and they had ended up killing this arson suspect, could be looking at a murder charge and the rest of their life in prison, which would not be good. I want to make clear, I'm not advocating that this arsonist should not be subject to citizen's arrest. I think they should be subject to citizen's arrest. Much more, by the way, arson is normally a deadly force crime. In my opinion, if the Utahns or the NYPD guys could lawfully carry guns in Georgia, and I didn't look into that. I don't know offhand if Georgia's like the constitutional carry state. That would apply to out-of-state residents. But in theory, or say it had been a pair of Georgia residents with a concealed carry permit, could they use deadly force to stop an imminent arson of a dwelling? Yes, absolutely. Absolutely. That's an imminent threat of death or serious bodily injury to people. So ironically, almost certainly under Georgia law, they would have been privileged to shoot and kill this crazy woman arsonist, but not to make a citizen's arrest. And that strikes me as rather awkward. All right, folks, let's take a look at the comments and questions from the Law of Self-Defense membership. While I'm doing that, keep in mind, you too can be a Law of Self-Defense member. It's only 99 cents, folks, for 2-week trial membership. After the 2 weeks, it's still less than $10 a day. Only $10 a day, $10 a month. Still less than 30 cents a day to be, about 30 cents a day to be a Law of Self-Defense member. Check it out. Take advantage of it right now, and you can join the commentary too on this live stream and every live stream during your membership at lawofselfdefense.com/trial. All right. Let's take a look. Good morning, everybody. Oh, Chris is in Brown Fells, Texas. Law of Self-Defense member Chris. Chuck is in Merritt, Texas. I'm, as I mentioned at the start, currently in Bernie, Texas, going up to Fredericksburg later today. Actually, first I'm going to go into San Antonio and check out the Alamo. Believe it or not, I've never been before. So this will be my day. And I was supposed to be on my way home already. I rode down here on a motorcycle. I was here for, if you don't know, for Donut Operators, Cody's Range Day. Hosted by himself, hosted by Brendan Herrera, the AK-47 guy, and hosted by Matt of Demolition Ranch. They've set up a gorgeous range that's only going to be more gorgeous. And they had a few friends, like 500 friends, come out and shoot a bunch of guns and machine guns. And we shot up a Humvee to destruction. At the end of the day, a mad minute of fire from everything from well, all kinds of rifle calibers and heavy machine guns. An M2 50 caliber machine gun, some crazy Japanese tank rifle was there with a magazine about as wide across as my MacBook Air. It was fun was had by all. The vendors were great. I've written a bit about this over on Twitter, on X, so you can check out my stuff there, photos, videos, and so forth. But that's where I am currently in Bernie, Texas. I don't know if the comments updated for me. That would be awkward. Let me refresh the page and see what we have. Let's see. Jared. Oh, I want to address this. Jared, law self-defense member Jared says, "Hi, Andrew. I just read a case out of Kansas called State v. Betts. The Kansas Supreme Court decision is contrary to what you say about innocent bystanders getting hurt in an otherwise lawful self-defense case." Jared, I made a note of that. If I have time this weekend, I will take a look at that case, and if it seems to have substance to it, I'll do a show on it next week. But for any of you folks, I love these things being brought to my attention. If you feel there's a piece of law out there that's inconsistent with what I'm saying, I want to know about it, because I am more than amenable to changing my legal opinion if there's evidence, if there's a substantive reason to do that. It doesn't happen very often. But anytime you think that's the case, normally what happens is there's a nuance that's not apparent to the person who thinks there may be an error. But sometimes I do make an error, so it's always worth taking a look at. Law self-defense member Chuck says, "I've been watching the citizen's arrest turn deadly, Georgia v. Hannah Payne." Yeah, of course, I'm traveling. That trial is streaming right now, live. This is a woman who observed a car accident, a hit and run scenario, pursued the hit and run driver, ended up shooting him and killing him. The driver was a 65-year-old black man. The woman was a 21-year-old white woman. And so, of course, the case has been racially energized, and she's on trial for murder and various other charges now. And she's claiming self-defense, that she had a gun for personal protection and turned into a struggle over the gun, and that's how the victim got shot here. A lot of interesting nuance there. If I was home in the office, I'd probably be live streaming it, but I'm not. Maybe I'll do it retrospectively. Law self-defense member Chuck again says, "An attorney goes into great detail about the dangers involved in a citizen's arrest. My advice is simpler: don't do it ever." Yeah, I don't tell people what to do, but I will say, defense of persons law, defense of yourself, defense of others is pretty consistent across the 50 states. It's about 80% the same across the 50 states. Once you get to defense of property, and you get to things like citizen's arrest, that varies enormously from state to state. And most of you don't know the citizen's arrest of your state. You really won't know it if you visit some other state. So when you think you're making a citizen's arrest, you don't have any idea if you're stepping over legal boundaries that could put you in a cage for the rest of your life. So certainly under that circumstance, I would suggest due caution before making a citizen's arrest. Even if you know what the law is, I would suggest due caution. Let's see. Law self-defense member Rick says, "Good morning from Maryland, but soon to be in San Antonio." It's nice here this time of year. I suspect it's closer to the surface of the sun in August, but I've never been to Texas Hill Country in August. Jeffrey says, "Comment, congrats on the Gundy Award nomination. Tough competition in your category." I don't think I got a Gundy nomination. I'm not sure I know what the Gundys are. I know Ian Runkle, who I saw here, he was also at this range day. So we had breakfast yesterday and hung out at the range, shot some guns together. I know Ian's routinely nominated for a gun day, but I hadn't heard that I was. I don't even know who those people are, to tell you the truth. And I'm sure they're very nice people. I've never been associated with them. Let's see. Yeah, I was here to hang out with, Donut, Brendan, and I met Matt, Demolition Ranch, for the first time. I also met Kentucky Ballistics for the first time this trip, which is very nice. You can't really hang out with Donut and Brandon at these events because there's 500 people here, however many there were, a huge number of people, and they all want those guys' attention. So, you get to say hello for a couple minutes and catch up and take a photo, and that's great. I'm ecstatic to have the opportunity to come down to this thing. Rick says, do you see making somebody wait for police a citizen's arrest? Yes. Any detention, you are arresting them. Think about arrest in the context of physics, not the law, right? There's an object in motion. You arrest the motion. You're stopping them. You're constraining them. You're inhibiting their free movement. That's all citizen's arrest. If I got nominated in the category of most influential voice in Second Amendment, I wouldn't accept the award. That's not me, folks. That's not what I do. So I have very strongly held opinions about the Second Amendment, but I don't consider myself. I know the real authorities in that space, and they're way, way above me. Let's see. All right, folks. Well, as I say, I have limited time. I got 28 minutes to pack up my hotel room, put everything on the bike, and get out of here before they get mad at me. So I'm going to wrap things up right now. Thank you for joining me for this, kind of a brief. I mean, frankly, all my shows should be about this length, 30 minutes. I just tend to talk too much. I really appreciate you all being here. And I remind all of you that if you carry a gun, so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict as well. Until next time, I remain attorney Andrew Branca for Law Self-Defense. Stay safe.